On the morning of May 20th, Wednesday 2026, Governor Siminalayi Fubara sat down in Port Harcourt and personally signed a one-page statement. It did not announce a fight, it announced a surrender. At least, that is how it read on the surface. He was withdrawing from the All Progressives Congress governorship primary, the same primary he had spent weeks preparing for, the same primary for which he had purchased nomination forms and passed screening just days earlier. By Thursday morning, 28 states were voting in APC governorship primaries, and Rivers was no longer one of them in any contested sense. A man who had cleared every hurdle walked away from the finish line with nothing in his hand, and 3 weeks later, the party he supposedly surrendered to is in a courtroom in Abuja defending the very candidate his withdrawal produced. Most channels gave you the headline, "Fubara steps down and moved on to the next story." We stay until we find the architecture underneath it. If you have never been here before, you just found the channel that tells you what the headline was designed to hide. Subscribe now, because what comes next is the part the APC's national leadership is hoping you never connect. The timing of Fubara's exit and the timing of a federal court suit against his own party's candidate are not two separate stories. They are one story told twice. Start with the sequence, because in Nigerian politics, sequence is the evidence. On Tuesday, May 12, 2026, a group of lawyers operating as incorporated trustees of the Association of Legislative Drafting and Advocacy Practitioners filed a suit at the Federal High Court in Abuja. The lawyers were drawn substantially from Obio-Akpor Federal Constituency, the same constituency represented by Kingsley Chinda, a known ally of FTT Minister Nyesom Wike, and at that point still the sitting minority leader of the House of Representatives under the PDP. The suit asked the court to stop the Independent Electoral Commission from recognizing Chinda as an APC candidate at all, on the grounds that his expected defection from the PDP to the APC would violate the Electoral Act 2026 and Section 68 of the 1999 Constitution governing legislative defection. On Tuesday, May 20th, 2026, 8 days after that suit was filed and 1 day before the scheduled primary, Fubara issued his withdrawal statement. He cited deep reflection and extensive consultations, framed it as a sacrifice for peace, stability, and unity, and pledged to support whoever emerged as the party's candidate. On Thursday, May 21st, 2026, the APC held its Rivers State governorship primary. By that point, Fubara had withdrawn, Tonyekole had withdrawn, Alabo Dako Renama George Kelly had withdrawn. Kingsley Chinda stood as the sole candidate and was declared the APC's governorship flag-bearer for Rivers State, while still, on paper, holding a House of Representatives seat and a leadership position obtained under the PDP banner. That's Thursday, May 21st. By the following week, Chinda had moved to formally resign from the PDP. A resignation letter dated April 23, 2026, read into the House record on Tuesday, June 2nd, weeks after he had already become the APC's candidate in waiting. That's the sequence. A defection-eligibility suit filed first, naming Chinda specifically. A governor's sudden withdrawal second, clearing Chinda's only intra-party obstruction. A primary producing a single unopposed candidate third, and a backdated resignation letter surfacing in public only after the legal exposure had attached to the candidate the withdrawal had created. There's a document at the center of this we have not yet examined, a one-page letter dated weeks before it was ever made public that the APC is now using as its primary defense in a federal courtroom. We come to that in Section 3.
Why now? Why would the timing of one governor's withdrawal align precisely with the timing of a lawsuit targeting a different man's candidacy? The answer sits inside the calendar of the 2027 election cycle itself. Late May 2026 was the deadline window for APC governorship primaries across all 28 states it controls. Section 87 of the Electoral Act 2026 is explicit on what happens when a party cannot produce a contested field. Where a party is unable to secure the written consent of all cleared aspirants for a consensus candidate, it must revert to direct primaries. In other words, the law assumes contest is the default, and consensus requires every cleared aspirant to formally step aside in writing. For Rivers APC's national leadership, a contested primary involving a sitting governor who had already passed screening carried real risk, not just of an embarrassing intra-party fight playing out on camera days before a court hearing on his rival's eligibility, but of a result that could not be cleanly walked back if the court later disqualified Chinda. A walkover, by contrast, produces a single candidate whose nomination can be defended as the product of voluntary consensus rather than a contested vote. Precisely the language APC National Chairman Nyesom Wike used afterward, repeatedly emphasizing that Fubara bought the forms, came for screening, passed the screening, and then pulled out on personal grounds. The calculation, if that is what it was, may have been incomplete. A walkover does not erase a defection-eligibility suit already filed 8 days earlier. It does not retroactively cure a minority leader's continued occupation of a PDP-won seat through April 2026. What it does is remove the one obstacle, a sitting governor's competing candidacy, that could have complicated the legal defense of Chinda's nomination by making the primary itself contestable on a second front. Nigeria has seen this pattern before. In the run-up to the 2023 cycle, several state chapters of major parties resolved internal primary disputes through last-minute consensus withdrawals timed to occur just before legal challenges to specific aspirant eligibility were due to be heard, producing unopposed candidates whose nominations were then defended in court as the product of party unity rather than contested process. The pattern is not unique to Rivers State or to the APC. It is a recurring feature of how Nigerian parties manage the collision between internal democracy requirements and external legal exposure. But what I just told you is the version visible from the outside, a governor stepping back to spare his party a messy primary days before a court case. What is actually happening, and who is really positioned to benefit from looking at the one document both sides have gone quiet?
That document is Kingsley Chinda's resignation letter from his position as House Minority Leader and, by extension, from active participation in the PDP. Here is what was claimed publicly, that Kingsley had ceased all PDP-related activities after April 2, 2026, in the words of the Center for Constitutional Governance and Electoral Integrity, the civil society group that has emerged as the most vocal public defender of his candidacy. The group's executive director stated plainly that those questioning Kingsley's eligibility should present one single proof anywhere in Nigeria that he attended any PDP function or acted as minority leader after that date. Here is what the documentary record actually shows. The letter announcing Kingsley's resignation as minority leader is dated April 23rd, but it was not read into the House of Representatives record until Tuesday, June 2nd, 12 days after Kingsley had already become the APC's sole governorship candidate following Fubara's withdrawal. Read that again slowly. The letter is dated April 23rd. It surfaces publicly on June 2nd. In between those two dates, a lawsuit was filed on May 12, specifically challenging whether Kingsley had properly severed his PDP ties before seeking the APC nomination, and a primary was held on May 21st in which he ran unopposed. The gap between the claim and the evidence is not about whether the letter exists. Nobody disputes that. The gap is about sequencing. A privately dated document, produced publicly only after the legal and political stakes of its timing had become acute, is being offered as proof of a fact, early clean severance from a rival party, that the public record cannot independently verify occurred when the letter says it did. This is precisely the territory the Electoral Act 2026 and Supreme Court precedent on defection were designed to police. The relevant legal standard is not whether a politician eventually resigns from a rival party, it is whether they continued to exercise the privileges of their original party's mandate, including occupying a seat won on that party's ticket after purporting to defect. A letter's date is evidence of intent to resign on that date only if it is corroborated by contemporaneous conduct, and the public record shows Kingsley functioning as PDP minority leader, at least nominally, well into the period the letter claims he had already stepped back. The CCGEI's framing, daring critics to find one instance of Kingsley acting as minority leader after April 2, inverts the actual burden under defection law, which falls on the defector to demonstrate clean and timely severance, not on critics to disprove a privately dated letter. If what I just laid out changes how you see this story, drop a comment right now. I want to know where you stood before this video, because what comes next is going to change it again. Here is what the sequence does simultaneously for three different actors. For Kingsley, Fubara's withdrawal converts a contested primary, one where a sitting governor with institutional resources could plausibly have won or at minimum forced a real contest, into an uncontested coronation. It removes the scenario in which Kingsley might have had to defend his candidacy in two arenas at once, an internal party vote and a federal courtroom. For Fubara, the withdrawal does something his public statement did not say out loud. By stepping back from a primary he had already passed screening for, Fubara avoids being the man who either lost to Wike's chosen candidate on camera or won and then had to govern Rivers State while that same candidate eligibility was being litigated in federal court. A scenario that would have kept Fubara entangled in Kingsley's legal exposure by association, as the man whose primary victory produced a candidate a court might later disqualify.
For the APC's national leadership, the sequence sets up the next phase cleanly, a single candidate framed as a product of voluntary consensus, defended in court by an outside civil society group rather than by the party machinery itself, creating a layer of distance between the APC's national leadership and the legal fight over its own candidate's eligibility. Now, assess Wike's position specifically, because his camp is the one absorbing the most exposure from this sequence. He is fighting on at least three fronts at once. First, the legal front. His closest Rivers ally's candidacy is the subject of a federal suit, and the central defense document has a sequencing problem that opposing counsel will almost certainly raise. Second, the public opinion front. Wike mocked Fubara's withdrawal, calling it a breach of gentlemanship for having bought nomination forms in the first place, language that read against the timeline could just as easily describe Wike's own ally's late surfacing resignation letter. Third, the political credibility front. Having spent over 2 years positioning himself as the guarantor of order in Rivers APC, Wike's chosen candidate now carries the one liability, contested eligibility, that Wike's entire strategy of consolidating the primary was supposed to eliminate. Everything I just told you about the political calculation assumes one thing is true, that Fubara's withdrawal was primarily about clearing Chinda's path. I want to test that assumption now. It is equally possible, and the public record does not allow us to rule this out, that Fubara's withdrawal was the price of the Tinubu brokered peace deal from December 2025, under which Fubara reportedly agreed not to seek a second term in exchange for completing his current tenure, and that the timing relative to the Chinda lawsuit is coincidental rather than coordinated. Both explanations are consistent with the public record. What is not in dispute is the effect. Regardless of why Fubara withdrew, the withdrawal's timing materially assisted Chinda's path to an uncontested nomination at the exact moment that nomination's legal foundation was under challenge. Zoom out from Rivers State, and this is not a story of two men's rivalry. It is a story about how Nigerian political parties resolve the collision between two legal requirements that were never designed to interact.
internal party democracy rules that assume contested primaries, and defection law that assumes clean, verifiable bricks between parties. When those systems collide, the path of least resistance for a party is not to resolve the underlying legal question, it is to remove the internal contest that would have made the legal question harder to manage. Rivers State in 2026 is demonstrating publicly how that resolution works in practice. This is not only a Nigerian story. International observers tracking Nigeria's 2027 electoral cycle, from election monitoring organizations to foreign chanceries with economic interests in the Niger Delta, read events like this as a signal of how durable any eventual outcome will be. A governorship candidate whose nomination remains under active federal litigation heading into a general election year is not a footnote. It is the kind of structural uncertainty that affects how seriously international partners treat the eventual result, especially in a state as economically significant as Rivers.
Now, the strongest case for the other side, because intellectual honesty requires it. If Chinda's defection was in fact properly executed by April 2, 2026, with the resignation letter genuinely written and acted upon on April 23, even if not formally read into the House record until June 2, a gap that can occur for entirely procedural reasons, including House scheduling and recess periods, then the entire sequencing argument collapses into coincidence. Politicians routinely resign positions privately well before public announcements, and a 5-week gap between a private resignation and its formal reading into parliamentary record is not, on its own, unusual in the Nigerian National Assembly. The CCGEI's challenge, produce evidence Chinda acted as minority leader after April 2, is a legitimate evidentiary standard if no such evidence exists, regardless of who first raised it. There is also a chilling effects dimension worth acknowledging, even though no defamation claim has been filed in this matter specifically. When eligibility challenges are filed against governorship candidates in the closing days before primaries, parties and candidates often argue, sometimes correctly, that such suits are themselves a political tool designed less to win in court than to create exactly the kind of public narrative this video is constructing. The fact that a lawsuit exists does not by itself establish that the conduct it alleges occurred. And here is a data point that complicates the clean narrative. Pre-election eligibility suits against ACP and PDP governorship candidates have been a near constant feature of every cycle since 2015, and the overwhelming majority do not result in disqualification before the election itself. Courts in Nigeria have historically been reluctant to remove a party's chosen candidate from the ballot on procedural defection grounds this close to a primary, often allowing the matter to proceed to the general election and be resolved, if at all, afterwards. The Chinda case may well follow that pattern regardless of how the timeline reads. The real battle is in the courtroom over the coming months, as the Federal High Court in Abuja considers the suit on its merits, and I do not know yet who is winning it. There are 3 paths from here. Path 1. The court dismisses or stays the suit against Chinda, likely on the grounds that the matter is not yet ripe, since Chinda has not yet been formally placed on an INEC ballot in 2027, and the entire sequencing gap becomes a historical footnote resolved by the simple fact that nothing happened to stop the nomination. Path 2. The court allows the suit to proceed to a substantive hearing on the defection timing question, forcing Chinda's legal team, and by extension the APC and CCGEI, to produce contemporaneous evidence beyond the April 23 letter that he had genuinely seized PDP functions by early April. This is the path where the sequencing gap identified in this video becomes legally, not just analytically, relevant. The path that ends Wike's current strategic position. The court finds sufficient question over Chinda's eligibility to order INEC not to recognize his candidacy pending further proceedings, at which point Rivers APC would face the scenario the May 21 walkover was apparently designed to avoid, reopening the candidate question, this time with Fubara already out of the race and no obvious consensus figure remaining.
3 signals to watch. First, any court date or ruling from the Federal High Court in Abuja on the Al-Drap suit. A substantive hearing date being set, rather than further adjournment, would indicate the matter is moving toward Path 2. If adjournments continue indefinitely, expect Path 1. Second, whether Fubara makes any public statement referencing the Chinda litigation specifically, as opposed to general APC unity messaging. Any direct comment would suggest Fubara sees his own withdrawal as connected to the case, while continued silence suggests the connection, if real, is one he prefers to leave unspoken. Third, whether additional documentation, House attendance records, PDP caucus minutes, committee assignments, surfaces showing Chinda's activity between April 2 and June 2, 2026 from either side. Such documentation appearing would resolve the sequencing question definitively. Its continued absence keeps the matter in the realm of inference rather than proof. At the beginning of this video, I told you that a man who had passed every screening hurdle walked away from the finish line with nothing in his hand, while the party he stepped aside for is now in a federal courtroom defending the candidate his absence produced. The deeper truth is this: Fubara's withdrawal did not resolve Rivers APC's legal exposure on the Chinda candidacy. It simply removed the one factor that would have made that exposure harder to manage politically. Whether that removal was the price of a peace deal, a calculated act of self-preservation, or simply convenient timing, the structural result is the same. Rivers State enters the 2027 cycle with its ruling party gubernatorial candidate's eligibility unresolved in federal court, and the governor who could have complicated that picture has stepped fully out of the frame. Watch for whether the Federal High Court in Abuja sets a substantive hearing date on the Aldrap suit before the end of Q3 2026. That single procedural step will tell you more about where this goes than any further statement from Wike, Fubara, or the APC national leadership combined. What this means beyond Rivers State is simple. When a single withdrawal can simultaneously satisfy a peace agreement, clear a legal obstacle for an ally, and remove a governor from a courtroom controversy, all without a single document changing, it tells you that the formal rules governing party primaries and candidate eligibility are doing less work than the informal choreography around them. That is not a Rivers State problem. That is what accountability journalism in Nigeria is up against heading into 2027. You now know something that most Nigerians watching the news tonight will never be told, that the timing of a governor's withdrawal and the timing of a federal lawsuit against his own party's replacement candidate line up in a way no official statement has acknowledged. If this changed how you see the Rivers APC story, share it with someone who only saw the headline. That is how accountability actually spreads, one informed person at a time. Naija Unmasked. Nothing stays hidden here. I will see you in the next one.